Good afternoon, everyone. My name is Alexis Alvarez, and I'm Director of Statewide Training at Florida Legal Services. We're here today for the final installment of our training series dedicated to this year's Domestic Violence Awareness Month, which is October. And I'm really excited to close this training session out with a very important topic, mastering your injunctions. So before we get started, I want to give a couple of housekeeping announcements. First and foremost, this is being recorded, and a copy of the recording will be sent to you all via Zoom within 24 hours. Along with that recording, you'll also receive the CLE credit. We do have a CLE approval. I'm happy to announce that. And so I will pop that CLE code into the chat. I will also say that CLE code out loud. And like I said, you'll get it in the email along with a copy of this recording. Third piece of housekeeping announcements are closed captions. They have been enabled. So anybody that needs that extra accessibility, you should be able to pop up the show captions button, and it should start showing you that transcription. If you're having any issues, please just message me independently and I will work to get you onboarded. Final piece of housekeeping announcements, questions and answers. Please feel free to drop your questions into the chat. I will be monitoring those questions and aggregating them to present them to our speaker at the end of our presentation today, if time permits. As I always say, I know it's tough in the virtual vortex to feel connected, but this important training and just this important month of awareness is important, and I'd like to encourage us to feel connected and to feel that this is a safe space to be able to ask the questions that you need in order to do the great work that you do. So, moving into introductions of our speaker here today, I feel very, very lucky to share this platform with Ananda. Ananda Balroop is a staff attorney for the Family Law Unit at Coast to Coast Legal Aid of South Florida. Ananda began her time with Coast to Coast Legal Aid of South Florida as a legal intern with the Family Law Unit, and it was here where she worked closely with pro se litigants at the Family Court Self-Advocacy Center, assisting hundreds of self-represented litigants with completing complicated family law forms and providing them with information and resources about the legal process. Prior to this position, Ananda was a paralegal for Coast to Coast Legal Aid's RISE unit, working with victims of crime. We know those folks. They gave us a really great training last week for those of you who are around. Currently, Ananda represents victims of intimate partner violence and helps them obtain domestic violence injunctions. She also represents individuals in paternity and dissolution of marriage actions. Prior to this position, Ananda was a paralegal for Coast to Coast Legal Aid's RISE unit. I said that already. I apologize. Working with victims of crime. Just an additional shout out for the RISE folks because of all the great work that they do. And so with that, I do want to say just a special thanks to Ananda for being here. Another shout out to Coast Legal Aid for just jumping on board when I'm curating this training series surrounding this important topic of domestic violence. And I'm really, really excited for you all to gather and gain the valuable knowledge on your strength and protection, how to master your domestic violence injunctions. And with that, Ananda, the floor is yours. Thank you so much for being here and everything you do for the survivor and domestic violence community.
Thank you so much, Alexis. Thank you so much for having us on behalf of Coast to Coast Legal Aid and myself. I'm going to go ahead and share my screen so that everyone can see this PowerPoint that we have prepared for today. Alexis, can you see the entire screen?
Sure can. Looks great.
Perfect. Right. Just as a disclaimer before we get started, this presentation is not intended to provide any legal advice. An overview for today's presentation, we're going to be talking about types of injunctions, the legal process, and a few fun hypotheticals at the end. So the 5 main types of injunctions are domestic violence, dating violence, sexual violence, stalking, repeat violence, and OVO petitions, which are on behalf of minor children. The first type of injunction is a domestic violence injunction, which is outlined and defined in Florida Statute 741.28. This type of injunction defines a family or household member as a current or former spouse, a relative related by blood or marriage, people that are residing together as a family unit. Same-sex partnerships are also included. An unmarried couple who have a child in common, regardless of their living situation. Domestic violence is also defined as assault, aggravated assault, battery, aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death of one family member or household member by another family or household member. Any person who is described above who is either a victim of domestic violence or has reasonable cause to believe that he or she is in imminent danger of becoming a victim of domestic violence has standing to file a petition. It's important to note here that the petitioner must prove that either he or she is a victim of domestic violence or he or she has reasonable cause to believe that they are in imminent danger of becoming a victim of domestic violence, but not both. So it's either or. Another major characteristic of domestic violence injunctions is that the parties usually live together or have lived together in the past, with the exception of parties who share a child. Moving on to dating violence injunctions. Dating violence injunctions are defined by Florida Statute 784.0461D, and it defines dating violence as violence between individuals who have or had a continuing and significant relationship of a romantic or intimate nature. The existence of such a relationship shall be determined based on the consideration of the following factors. The relationship must have existed within the past 6 months. The nature of the relationship must have been characterized by the expectation of affection or sexual involvement between the parties, and the frequency and type of interaction between the persons involved in the relationship must have included that the persons have been involved over time on a continuous basis during the course of the relationship. This does not include violence in a casual acquaintanceship. Violence is also defined the same way as domestic violence was defined earlier. Standing for a person to file a dating violence injunction has to be a person who's a victim of dating violence and has reasonable cause to believe he or she is in imminent danger of becoming the victim of another act of dating violence, or any person who has a reasonable cause to believe he or she is in imminent danger of becoming a victim of dating violence, or the parent or legal guardian of any child who's living at home who seeks an injunction for protection against dating violence has standing to file a petition in court. It's important to note here that the distinction between dating violence and domestic violence is that the petitioner must prove both. The petitioner must prove that they're a victim of dating violence and they have reasonable cause to believe that they're in imminent danger of becoming a victim of another act of dating violence. Next, we move on to sexual violence. Sexual violence is defined by statute 784046(1)C. It includes any one incident of sexual battery, a lewd or lascivious act committed upon or in the presence of a person younger than 16 years of age, luring or enticing a child, sexual performance by a child, or any other forcible felony wherein a sexual act is committed or attempted, regardless of whether criminal charges based on the incident were filed. A person who's the victim of sexual violence, or the parent or legal guardian of a minor child who's living at home, who is the victim of sexual violence, has standing to file a petition on their own or on behalf of their child if the person has reported the sexual violence to a law enforcement agency and is cooperating in any criminal proceeding against the respondent, regardless of whether criminal charges based on the sexual violence have been filed, reduced, or dismissed by the state attorney, or the respondent committed the sexual violence against the victim or minor child, was sentenced to a term of imprisonment in state prison for the sexual violence, and the respondent's term of imprisonment has expired or is due to expire within 90 days following the date of the petition filed. Moving on to stalking. Stalking is defined as a person who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person, commits the offense of stalking. Stalking is defined by Florida Statute 784.048. The definition of harass means to engage in a course of conduct directed at a specific person, which causes substantial emotional distress to that person and serves no legitimate purpose. A course of conduct is defined as a pattern of conduct composed over a series of acts over a period of time, however short, which shows a continuity of purpose. It's important to note here that cyberstalking is also included in stalking and is defined as engaging in a course of conduct to communicate or cause to be communicated directly or indirectly through the use of email or electronic communication directed at or pertaining to a specific person to access their online accounts or home electronic systems without their permission, which causes substantial emotional distress to that person and serves no legitimate purpose. Next, we move on to repeat violence injunctions, which are defined by Florida Statute 784.0461B. Repeat violence means 2 incidents of violence or stalking committed by the respondent, one of which must have been within 6 months of filing of the petition, which are directed against the petitioner or the petitioner's immediate family members. Violence is defined the same way as the previous domestic violence statute. It's important to note here that for repeat violence injunctions, there's no requirement for the parties to be related or have any sort of relationship. Typically with repeat violence injunctions, the parties are neighbors, co-workers, or classmates. Now we're going to pivot to Grayson's Law. And the reason that we are going to discuss Grayson's Law today is because it has modified chapter Florida Statute 741.30 on domestic violence injunctions, as well as the petition for injunction for protection against domestic violence. It recently became effective as of July 1st, 2023. Grayson's Law originated in response to the unfortunate death of Grayson Kessler, who was the victim of a murder-suicide involving his father. Prior to the murder, Grayson's father had sent disturbing messages to his mother, which prompted her to file a petition for injunction. Unfortunately, she was denied an injunction for protection because the law had no formal mechanism that allowed for threats directed at a parent to create a nexus with the child. Specifically, Grayson's Law has added a factor that the court must consider when determining if a petitioner has reasonable cause to believe he or she is in imminent danger of becoming a victim of domestic violence. Factor 10, which was included, now reads as whether the respondent has or had engaged in a pattern of abusive, threatening, intimidating, or controlling behavior composed of a series of acts over a period of time, however short, which evidences a continuity of purpose and which reasonably causes the petitioner to believe that the petitioner or his or her minor child or children are in imminent danger of becoming victims of any act of domestic violence. Specifically in the petition, which has been updated, Factor K has now been added to accommodate Grayson's Law. Now we move on to filing a petition for injunction for protection. So the initial process is ex parte, which means that a judge will review the petition without hearing from the other side or the respondent. There are several options that may happen at this point. The first option is that the petition may be denied. The petitioner will have no protection. At this point, the petitioner may file a supplemental affidavit in support of their petition to add additional incidents in hopes of obtaining a temporary injunction. The other thing that may happen is that there may be an order setting a hearing on the petition, but no temporary injunction has been issued. At this point, the petitioner has the option to withdraw their petition before the packet goes out for service on the respondent, or the petitioner can file a supplemental affidavit to support their original petition. The third option is a temporary injunction for protection is issued. At this point, the petitioner will leave court with the protection of a temporary injunction, and a return hearing is typically set for 15 days. Here in Broward County, the packet will go out for service to Broward Sheriff's Office. The packet will include the temporary injunction, the notice of hearing, and the petition for injunction for protection. If the case involves the need for financial support, typically a petitioner will file a financial affidavit, and if it involves children between the parties, then the petitioner would be required to file a Uniform Child Custody Jurisdiction and Enforcement Act affidavit. All of the forms can be found on flcourts.org or .gov. And here we have a sample of the petition for injunction for protection against domestic violence that's recently been updated. The form is very easy to follow for a petitioner. It asks for their information, for the information on the respondent. It gets into the case history and how the parties known each other and how long they've known each other. Most notably, it will list the factors that the petitioner can indicate that has caused them to file a petition for injunction. You can see factor K here, which was recently added. And then there's a section where the petitioner will describe the incidents of domestic violence that caused them to file this petition for injunction. The petitioner also may ask for temporary exclusive use and possession of the home that's shared by the parties. They can also ask for temporary parenting plan or a temporary time-sharing schedule if the respondent and the petitioner have children in common. It is important to note here that the court may deny this request for a temporary parenting plan or a temporary time-sharing schedule if paternity had not been established either through marriage or a court order. Another important addition is that now petitioners may request exclusive care and possession or control of a family pet. They can also ask for temporary support. And this is basically what the petition for injunction looks like. Some other forms that are included with the petition would be a notice of related cases, the respondent description information sheet, notice of social security number, the clerk's affidavit of related cases, a request for confidential filing of an address. Here in Broward, we have the petitioner's waiver. Basically alerts the petitioners if they don't pick up their restraining order, it lets them know that a copy of the restraining order will be sent to the respondent for service. So it lets them know that they may be late to picking up their injunction, but the respondent may know before they do if they are. Another option that's unique to Broward is that the petitioner may decide how they want to proceed if the court does not enter an ex parte temporary injunction. So this is what this form looks like. It's on the right-hand side, and it basically gives the petitioner an option. If they are not granted a temporary injunction, they can ask the court to have a hearing set on their petition, even though they were not granted a temporary injunction. At that point, they can supplement and do what they need to do to hopefully get a temporary injunction. Or they have the option of saying that they don't want a hearing to be scheduled. They don't want the respondent to be notified that they even filed a petition for injunction against them, and they're giving up their right to a final hearing. A lot of the times, this is helpful for clients who are in an extremely dangerous situation, and if this may further put them in danger without having the protection of a temporary injunction, then they would opt for option B. This is just another note on pets. When filing a petition for an injunction, here it specifically states where you can request exclusive care, possession, or control of family pets. Unfortunately, a lot of times abusers use the family pet as a way to control the victim. We've seen that happen in a lot of cases, and sometimes they even harm the family pet as a way of harming the victim. So now pets are included to avoid that kind of situation. What happens when a temporary injunction for protection is now issued is that the case will be assigned a name, and it'll also be assigned a case number. Then there will be a notice of hearing attached to that temporary injunction, giving the judge's name, the courtroom, the date, and the time. What the temporary injunction would now include is that all violence and contact is prohibited against the petitioner by the respondent, whether it's direct or indirect. The respondent cannot go within 500 feet of the petitioner's residence, workplace, school, or wherever they may frequent. The respondent cannot go within 100 feet of the petitioner's vehicle. The respondent is not allowed to have any firearms, ammunition, or concealed weapons permits. If the petitioner requested temporary exclusive use and possession of the home, then that may also be awarded to the petitioner. The petitioner can also ask for temporary time sharing over the party's children if they have children in common. Temporary injunctions are also enforceable by arrest. Moving on to the service of injunction. What's important to note here is that injunctions need to be served by law enforcement officers. So when it's issued, it has to be served upon the respondent by law enforcement. A process server should not be used. Also interesting here is that a petitioner may request the assistance of law enforcement to place them in possession of a dwelling or a residence that they asked for in their initial petition and was awarded to them in their temporary injunction. It works in the opposite. If a respondent needs to return to their home to gather their belongings, they may ask for the assistance of law enforcement to return to that home to get their items in order to find a new place to stay if a temporary injunction has been issued to the petitioner. Also, when a respondent is served with a temporary injunction and the petition, law enforcement typically should ask the respondent if they have any firearms or any weapons on them. They should then retrieve those firearms and provide the respondent with a receipt of those firearms and document what is said about the firearm. Because when a temporary injunction is issued, the respondent is no longer allowed to have any firearms in their possession or control or any concealed weapons permit. Now we move on to the final hearing. This is the final step after a petitioner has filed a petition for injunction. At the final hearing, there are two different options. There can be an agreement that's been reached by the parties, which typically looks like the parties are agreeing to all the terms of the injunction. They can agree on a time frame, or sometimes they can agree until further order of the court. That would be entered by agreement at the final hearing. If the parties don't agree, then what they will have is an evidentiary hearing. If there is a hearing, testimony will be given by the petitioner and any witnesses that the petitioner has who have personal knowledge of the incidents that happened. Some witnesses include officers who responded to the incident of domestic violence, who may have taken pictures, who may have witnessed, what the petitioner looked like when they appeared on the scene, if they observed any injuries or bruises or damage to the petitioner. Those are things that the officer may testify about in court, and what they did eventually when they arrived to the scene, if they made an arrest or not. Other evidence is presented at an evidentiary hearing, such as pictures of injuries, broken bones, ripped clothing. All these things would count as evidence at an evidentiary hearing. However, it is common for sometimes victims to not have any witnesses or physical evidence. If that's the case, then the petitioner will be testifying, and that will be their primary evidence as to what happened and why they're seeking this petition for injunction. We always encourage our clients to take their own pictures at the time of the incident so that they can show what happened and have a recollection of the time and be able to prove in court that this photo was taken at this time and it's reflecting the injuries that they wrote about in their petition. Unfortunately, many abusers sometimes delete photos from phones or storage, whatever storage that the petitioner may have. So we always advise our clients also to send them to a trusted friend or family member so that it preserves photos and evidence for future use if they need it. After a hearing, the judge will make a decision. the judge will either grant a final judgment of injunction for protection or deny the entry of a final judgment and dismiss the temporary injunction. Typically, dismissals are done without prejudice. Some of the terms of a final judgment of injunction, whether it's entered by agreement or through an evidentiary hearing, include that all violence and contact from the respondent is prohibited, whether it's direct or indirect. Specifically, judges will make sure that respondents know that they can't have their family members contact the petitioner. They can't use social media to contact the petitioner, like they can't use Instagram or Facebook Messenger, whether it's through a friend or directly. All of that will be prohibited. The respondent then cannot go within 500 feet of the petitioner's residence, wherever they work, go to school, or where they go often with their children. The respondent is not allowed to have any firearms, ammunition, or concealed weapons permits. The respondent cannot go within 100 feet of the petitioner's vehicle, whether or not it's occupied. The petitioner may have been awarded temporary exclusive use and possession of the home. They may be awarded temporary time sharing of their minor children. If they asked for temporary child support and alimony, that may be awarded to them as well. Sometimes the judge will order the respondent to submit to a batterer's intervention program. They may have to do substance evaluation and treatment. They can be ordered to do a mental health evaluation and treatment. Final judgments are also enforceable by arrest or reporting violations to the clerk of court and the state attorney's office. Again, violations can be reported to the police. The petitioner can file an affidavit of violation, or they can contact the state attorney's office. An important thing to note here at this point is that a victim cannot violate his or her own injunction for protection. It is only against the respondent. They're restrained from contacting the petitioner or coming within 500 feet of where they are. It's important to note this because sometimes we have clients who feel like they could be in violation if they accidentally see the respondent somewhere. They feel like they may be in violation of their own injunction, which is actually not true. So it's important that our victims know that. Oftentimes, when a petitioner files a petition for injunction, the state attorney's office may decide to file criminal charges against the respondent based on those same allegations in their petition for injunction. So respondents are usually ordered to follow pretrial release conditions in their criminal cases, if there is a criminal case, which typically includes no contact with the victim. So a violation of an injunction can also be a violation of a criminal no contact condition, or could be considered tampering with a witness in a criminal case. Now we move on to some fun hypotheticals to sort of wrap up today's presentation. I would encourage you all to put in the chat box your responses. Lucy is seeking an injunction against Ricky, the father of her child. During an exchange of their child outside of Lucy's home, Ricky pushed Lucy against the car door and spat in her face. The parties are not married and have never lived together. What type of injunction should Lucy file?
And you have some answers coming into the chat. Are you able to see them?
I cannot see them.
Okay, so I can read some of them out loud to you. We have people saying domestic violence, DV, domestic violence. One person said DV with minor children, and the last person said DV.
So, move on to the next slide and get the answer. So whoever said a petition for injunction for protection against domestic violence is correct. That is the answer. At this point, I would ask you why. You can type in your response why you chose domestic violence, and we can further discuss. If you want to share some of those responses.
Yeah, I'll read out loud what comes in through the chat. Someone here said child in common, they have a child in common. That seems to be the general consensus.
Right, so although they never lived together, they do share a child, so that is why she can file technically under domestic violence injunction. Also, in Lucy's petition, What can she request in regards to time sharing or future exchanges? What are some of the ideas, or what are some of the things that you all think she may request? Well, feel free to put it in the chat so we can.
Waiting on some things into the chat. So maybe repeat the question.
Sure. So what are when filing her petition for injunction, what can Lucy request in regards to time sharing with her minor child?
Okay, so folks are saying child support, 100% time sharing, supervised visits and hands off, child support with 100% time sharing.
Absolutely. Those are all things that she may request. But I would say that Lucy would probably want to request that future exchanges are facilitated by a neutral third party. She can ask for exchanges to be done at a public location, so that way it's not at her home and she's not putting herself in further danger. And she can also ask for 100% temporary time sharing of her minor child. You guys did great. Moving on to the second hypothetical. Ashley dated John for 2 years. 3 months ago, their relationship ended when Ashley learned of John's infidelity. When Ashley confronted John, he slapped her across her face and threatened to hurt her if she told anyone of their friends about it. Since the relationship ended, Ashley has noticed John's car at her parking lot at work and at random times in her apartment complex parking lot. John also messages her weekly, reminding her that if anyone finds out about why they broke up, he will find her and hurt her. What type of injunction does Ashley have standing on her?
So the first thing that came in was dating violence, a second for dating violence, a third for dating violence, a fourth for dating violence. Oh, dating stalking.
Oh, okay. Okay. So let's move on to the answer. So those who said a petition for injunction for protection against dating violence were correct. And that's because that they were in a relationship that was in the last 6 months. And Ashley can further show that she has reasonable fear to believe she's in imminent danger of becoming a victim of another act of dating violence because of his continued behavior. Moving to the last hypothetical. So Pam and Jim started dating 2 years ago and eventually lived together for 6 months. They ended their relationship a month ago and no longer live together. A week ago, Pam received a note on her windshield with the words, "I am always watching you." She immediately recognizes Jim's handwriting and is terrified. She then received several calls from a blocked number in the days following the message. The next week, she noticed Jim's car following her home from work. He was speeding up and trying to crash into her car, causing her to swerve off of the road. What type of injunction should she file?
All right, someone DV, DV. Waiting on some more folks. I guess it doesn't rise exactly to the level of stalking, or does it? That's as someone that doesn't do this work. I'm like,
Well, it seems like stalking.
Seems like it to me. Someone said stalking. They lived together 2 years ago, question mark.
Right. So
Tell the word repeated in there.
all right. So this can be a petition for injunction for protection against domestic violence. So
Okay.
It seems like stalking, but it could be DV. It could be domestic violence.
There you go. And the last person wrote in DV or repeat stalking.
Right. And so it's because they live together as a family, and now he's stalking her and trying to harm her. So she could file a petition for injunction for protection against domestic violence. Right. That was our last hypothetical. That concludes the presentation for today. Here it's a little bit, we discussed here what Coast to Coast Legal Aid of South Florida services, the types of services that we provide. If you'd like more information, you can follow us on our website or social media. Thank you all so much for your time today and for giving us this opportunity to present on domestic violence injunction.
Awesome. Thank you. I'm going to remove your screen share for now, so that way you can see the chat and you can see everything and see if anybody, oh, you got it. You did it for me. And, just to let folks know, if you can see, we also have Victoria Sexton on here, who's done a few different trainings for us as well on this topic. So she's passively involved right now, but we may entice her to be more involved depending on what she's interested in doing as far as your questions and answers go. So folks, we brushed over, a lot of things. This is really, really an in-depth topic. So does anyone have any specific questions over what we discussed that you want to drop in the chat? In the meantime, while you all are thinking and we have a little bit of time, I'm going to ask a question that came to my mind, which is, and I'm someone that doesn't work in this field, so disclaimer. It seems to me that sometimes fact scenarios can lend themselves to different types of injunctions, that really there are maybe multiple avenues that a person can travel under. Just strategically, how do you, when you know that somebody might qualify for multiple types of injunctions, are you able to file for multiple, or do you have to make that judgment call? And how do you kind of go about that decision-making process?
So typically we advise our clients to file under domestic violence if they can. Domestic violence, as we discussed before, the petitioner has to prove that they're a victim of domestic violence or that they have reasonable cause to believe that they're in imminent danger. So those types of injunctions are more encompassing and they're easier to prove in court. So we typically would advise, if there's a situation and it applies to the client and they can file under this type of injunction, then that's what we would advise them to do. We always try to make it a domestic violence injunction if possible and if their situation fits those facts.
Second question, I know we talked a little bit about Grayson's Law in the beginning. As a training director, I've received a lot of requests for training on Grayson's Law, and the reality is it's just not really a robust body of law yet. There hasn't been a lot out there as far as how it's been used or relied on, or successful cases or not successful cases. In your experience, have you seen it in practice yet? Have you seen it be used, and how have you seen it been used, and where have you found it effective, if so?
It's still very new. We have heard that it's been working for some individuals who have argued, that the other parent's behavior has been concerning, that although it's directed towards them, that there is a nexus between the child being with a safe parent. So we have heard that it is successful, but it is still very, very new. We do like that it includes an additional factor into the petition. For petitioners, when they are filling out their petition, it's something that they can include, and it will count towards the court determining whether or not they have reasonable cause to believe they're in imminent danger.
Got it. And so, I don't know, let me think. Anyone have any questions? Anything coming in through the chat? I know we covered a lot. And, I know some folks struggle to type things into the chat if it's a more complicated fact scenario. So if you, would like to be taken off mute to propose a question individually, I can give you that power. If you just raise your hand, I'll keep an eye out. I do see a question that came in through the Q&A. Somebody asked, how do you combat a situation where a victim of domestic violence is an unwed mother and the adverse party is the father who has not established paternity, i.e. the victim has 100% time sharing rights to the child, and the judge uses the victim's injunction to award time sharing to the abuser?
Well, this is very fact specific.
Very complicated. And if you want to look at it, if you click at the bottom, there should be a Q&A. You can click that and it'll come up and you can actually read it again if you need to.
So I mean, in arguing a case like this, if the adverse party, has not established paternity, as we discussed earlier, now the petitions, there's a note on the petition that the court may deny any sort of temporary time sharing if paternity has not been established either through a dissolution, either through marriage or any other type of court order. So if the adverse party poses a threat to the child or the child witnessed the domestic violence, then those are things that we would bring to the judge's attention. If there's any reason that this child should not be with the adverse party on their own, then those are things that we want to make sure the judge is aware of, and we can do that through the petitioner's testimony, through witnesses who maybe witnessed the situation and saw that the child was there and involved. Those are ways in which we can address the issue of domestic violence when there's a child involved. I hope that answers the question.
Sure. And then somebody asked as well, any success with stalking injunctions?
We've seen a few. It is more difficult. One of the injunctions, they are a little bit more challenging to prove. But once you have your evidence and you have, you show that this person is really, there's no legitimate purpose for what they're doing, and it's causing, emotional distress, then those are things that you want to make sure that you bring to the judge's attention.
And, on that note, it makes me think, sorry if I'm having a little feedback, in those successful stalking injunction cases, you mentioned, you have your evidence, you have this, like, what have you seen makes a strong, stalking injunction? Just kind of generally, I know it's hard probably to say the gamut, but generally, like, what to look out for as a practitioner when you're like, oh, this actually is a strong stalking injunction.
Once you can show that this person is contacting the other person, there's no reason for it, and it's actually causing the petitioner to have substantial emotional distress. Once you can clearly prove that, I think then you could be successful in obtaining a stalking injunction. It's also, cyber stalking is a really big one. We see where people are, making fake social media accounts and pretending to be the petitioner. Once you can show that this account, was created by this person, or, there's no reason for it, and then it was done by the respondent, then those are examples where, we'd be successful in a stalking injunction.
That's tough. How do you even go about really proving, who made a profile or who is,
Right.
I guess I'm trying to think back to my days in litigation, and I'm thinking common terms or phrases a person might use for a person, right? Like, so if you have a profile that you're making as an abuser and you're harassing a victim, but you use like a name that only the abusers ever used to call the victim, that could be evidence that could tie in. Maybe that's a whole new training that we need to do.
Yeah, and you want to show that there's a pattern. You want to show that this has been happening over time and there's no reason for it. Yeah. So that's definitely what would make a successful stalking injunction.
All right, so another question came in. It says, do judges typically consider conditional threats as legitimate threats? How explicit does the threat need to be? It's a great question.
I think usually we get threats where someone says, oh, I'm going to hurt you, or I'm going to punch you, or I'm going to kill you. And I think once the petitioner testifies about the way the threat was made, circumstances in which it was made, how it was made, and what the threat actually is, I think judges do consider that. They do consider also if there was physical violence after the threat was made. That's something that I think will weigh heavy in a judge's mind. I think they would see that, okay, this person made a threat and also followed through on it. So that's definitely something that a judge would consider.
So I'm going to ask a tough question. I am so sorry. I'm not sure why my feedback is the way it is right now, but a tough question that I think is a tough question is, so you have someone who comes to you and they're looking for you to file an injunction for them. And maybe you as an attorney believe that there is some credible fear, there is some violence this person is experiencing, there is something, but it doesn't rise to enough for anything, or at least for what you think might have teeth. How do you handle those situations as someone who's passionate, certainly, about, victims and survivors of domestic violence, but also as a lawyer that has to make, those calls?
So first we advise them of the law, and we explain to them, what they have to prove under the statute. And we'd explain that based on what they're saying, maybe it doesn't meet the statutory requirement. But however, we encourage them to document certain things if things are happening and they're in fear. We advise them to call the police immediately if they feel like they're being followed, or if they feel like, for whatever reason, they feel like they're in danger. We would always advise our clients to call the police first and foremost. And also, we never discourage anyone from filing a petition for injunction. If they truly feel that they have been a victim or they are in imminent danger of becoming a victim, then we explain to them, maybe your injunction right now, what you're saying does not meet the statutory requirements. But if you truly feel that you are in danger, in imminent danger of becoming a victim, then file a petition. The worst that can happen is that it's denied, and then we can figure out, what to do next. So we try to tell our clients to always document things, take pictures, make sure you call the police if you don't feel safe. And that's typically the advice that we would give someone that comes to us in a situation like that.
Awesome. Well, I'm typing away because I'm popping the CLE code in the chat for folks. Lately, I've just been very engrossed, especially in all of the awesome trainings that we've had on this topic this month. So I keep forgetting to pop it in there before I turn on. But the CLE code is 231061, N as in Nancy. Let me just triple check that. And that is for one general CLE credit and one marriage and family law certification credit. So I know those are kind of tough to get sometimes. So this got it. Before we go into those closing remarks, does anybody have any other questions? Somebody wrote in the chat 617. I'm not sure what you're referring to, but the CLE code is typed into the chat. And it is 23106117, N as in Nancy. Again, it's typed into the chat, and you will receive that CLE code in writing again with a copy of this recording from Zoom in 24 hours. I don't see any other questions that have come in. So before we sign off, is there anything else that you want to touch on or share or say in regard to this type of work, or generally about this awareness month or anything particular?
Yeah, so just would like to, you don't have to know the law to spot the signs of domestic violence. So I would say, if someone comes to you and they're saying that they're in danger, they don't feel safe, believe them. Victims know their situation better than we do, even if it's a situation where it may not rise to the level of filing a petition for an injunction. Maybe it's not there yet, unfortunately, but maybe it will be. So be compassionate to victims that come to you, or individuals that come to you that may have a situation like this, because at the end of the day, we don't know what their lives are like and what their situations are like, and it may seem like nothing, but it could very well be something. So be compassionate to individuals who come to you for help with injunctions or domestic violence.
Absolutely. It's a really great sentiment to end not only this training today, but overall the training series that we've dedicated in honor to this month. And on that same note, I always remind people it's a month of awareness, but it's a lifetime of work and a lifetime of trauma that people experience. And so even though our trainings on the topic of domestic violence do seem to be concentrated in this month for recognition of this month, I encourage everyone to continue with that awareness, continue with that education, always stay abreast of everything, and always reach out if you need a training on a particular topic or think it would be helpful, especially in this important sphere. I'm always here to bring it to your front door, which I couldn't do without trainers and presenters and amazing folks like Ananda. So thank you very much for really being the closer on this training series and providing us with all of your knowledge.
Thank you so much for having us. We really appreciate your time.
All right, folks. Well, you'll receive an email from Zoom 24 hours. You need anything before then, or you don't see that email, you'll have my email address in the chat. Jot it down real quick, copy paste. You can always reach out to me directly and I will get you what you need. Lots of thanks coming in through the chat. Great presentation. And on that note, I think we can all have a good rest of our day. Happy Halloween.
Happy Halloween, guys. Thank you.
Yeah, I can't believe it's already the end of October. Welcoming November tomorrow.
Yeah.
All right, everyone. Have a great rest of your day.
Thank you. Bye-bye.